friends, those who have been connected with us know that this is the second session on the art of the contracts, of effective contracts. Today's masterclass is the art of effective contracts. As we all know that the contracts and its drafting play a vital role for any organization, or for that matter, any agreement. But it only varies as to what nature of contract it is. Yes, for any contract, there are certain basic fundamentals at who is the party A, party B, first party, second party, or what will be the domain of that particular contract. Then where will the litigation, if at all lies, would come into being, and then date of entering the contract, the nature and mode of dispute redressal forum nowadays, which is becoming very common, as to whether we are going for an alternate dispute redressal forum, etc. But be that as it may, whatever contracts we do, if one knows while drafting a contract or making an how the contract has to be effective. In all these masterclass, not only on Beyond Law CLC, but anywhere we go, or even if we read books like what Mr. Bhumesh Verma is written, and those who have been following him up, he always gives one tip. Today probably was 108th tip or 107th as to what could be the effective contract to be written. But if one knows that what are the guidelines, or what we say Lakshman Rekhas to be followed, so that two things become important while we frame a contract. Number one, the clarity of thought, what it is intended for, why it is intended for, and what is the master chart or road ahead for that. And then it will be how to, let's assume there is a dispute, why it is there, what is the remedy, and how it is to be resolved. Then whether if there are any damages, how to go about it. Or contract for that matter, it could be any, I would take rather a rental agreement contract. All contracts are contracts, but what are the way forward which should be kept in mind, and how, as Mr. Bhumesh has rightly put the session, how to make it an effective contract. Effective contract means it's not a paperless tiger that you make on contract, but effectively by the end of the day, nothing comes forward. So without taking much time, since we know that it's a working day and we are also around the corner with Diwali, so I will request Mr. Bhumesh to take forward. Unmute. You will have to unmute yourself. Yeah.
Thank you so much, Vikas, and wonderful audience we have got. We've got like 35 odd participants today. My greetings to all in this festive season. Wish you very happy, healthy Diwali amidst all the pollution we are witnessing in Delhi or NCR in particular. However, let's try to be safe. We have a pandemic upon us, we have pollution, and we have cold. Let's be safe. Now, the topic for today's discussion is effective contracts. Many of you would have attended our first session a couple of weeks back, wherein we discussed the broad parameters of contract drafting. Today, we will take our discussion a bit further into what aspects we should keep paramount when we get to draft. What is the essence of effective contracts? Like as Vikas said, a contract should not be a paper tiger. It should be a biting tiger. So effective contracts are the crux of any successful commercial dealings. Unless your understanding is backed by an effective contract, it is of no use. Let me take you through a slideshow. Let me share my screen. The admin can please allow me to share my screen. Yes. Okay. Okay, I hope my screen is visible. No, this is okay. Last week's slide, not this one. I have to another one. Just give me a moment. Some lag with my screen. Just give me a moment. You know, technology ditches us when we need it the most. Okay. Yes, I hope my screen is visible. Great. So this is some bit of information about me for those who may have not attended the last session. Okay, now what is an effective contract? Vikasji, what are the first thoughts that come to our mind when we think or talk about an effective contract? There are contracts and contracts everywhere. In the last session we discussed, we are surrounded by contracts day in, day out in our personal lives as well as professional lives.
That's true.
What distinguishes an effective contract from an ineffective one? What are the
According to
first
me,
thoughts that come to our mind when we think of an effective contract?
according to me, it will be that whatever you effect actually want to get through that contract should be really reflect from that, which is capable to be entered and understood by even a common man.
Right, right. So, first things first, a contract should be understandable. Whosoever is reading it should be able to understand it. That is the first, touchstone of an effective contract, that it is understandable. Being understandable is the first issue. Second issue is it has to be implementable. The working framework should be such that it can be easily, seamlessly implemented, because a good understanding, a good commercial arrangement, a good bargain is of no use if it cannot be put into implementation stage. Unless you can actually work on a commercial understanding, it is of no use. So I would say, stemming from the drafting, first thing is clarity of thought process, understanding, and then whosoever is reading it, whosoever is supposed to implement it, work upon it, the management, the technicians, whosoever is supposed to work on it should be able to implement it. Good. We have reached the stage of implementation. Very good. Working framework is good. But are the parties on the same page throughout the tenure or the term of the contract? That is another parameter of gauging the effectiveness of a contract. Do the contract terms lead to misunderstanding, gaps, ambiguity, issues, disputes between the parties? Or does it remain seamless easy to understand and operate throughout. That is another important yardstick. So an effective contract, a good contract, is the one which leads to least disputes. So the key lies in sorting out as many issues as possible in the beginning so that there is least scope for disputes to arise. Next, all said and done, we have not been able to eradicate disputes completely. There is a dispute. Do we have a good, effective framework to deal with these disputes? Is this dispute resolution mechanism expeditious, economical, proportionate, commensurate to the subject matter? That is next yardstick. Okay, we tried even dispute resolution, but the parties have not been able to overcome their disputes, or even otherwise parties are in the habit of offending each other, breaching material terms of the contract time and again. Do we have an efficient termination system in place whereby one party can exit out of this relationship if the going is not good, or if both or all the parties are not happy with the way things are going, the milestones are not being met, payments are not being made, production or services is not satisfactory, or compliance with terms and conditions is not satisfactory? Do the parties have a harmonious way of getting out of this uneasy relationship? So these are some most important parameters to measure the effectiveness, the efficiency of a contract. So today we will touch upon some of these issues. How can we make our contracts effective? What steps can we take towards this? So last time also we touched upon briefly on the divergence as far as clients, draftsmen, the people who are to implement, and the people who are supposed to enforce the contract. Because sometimes what the client express to us as to what they want to be undertaken under this contract, what interests they want to be protected, what liabilities or exposure they want to be limited, what powers to be enhanced, and so on and so forth. What does the client think of this contract? How much important this contract is for a particular client? What is the client's expectation from this? So first we have to gauge all that. We have to capture everything, and then we have to draft. So what we draft, does it match with the client's expressions? Whatever the client has told us, have we captured everything? Have we taken into account all the expectations from the clients? There could be a divergence between these 2-3 stages. And thereafter, whatever we have drafted, if it is not easily understandable, or there is a lacuna in the implementation process demarcated in the contract, there could be gaps in drafting of the contract and implementation of the contract as well. And if the implementation is not good, definitely there are going to be disputes between the parties, divergence of opinion, ambiguity, disputes. All these issues will come into play if implementation is not effective. Because if implementation is not effective, the parties will not get the desired results from the commercial understanding. So what do you do then? Then you will have to enforce it. So these are different stages at which there is a scope for divergence between expectations of different quarters. An agreement or a contract is not an exercise in isolation. It has so many stakeholders. The parties to the contract the people who are going to implement it, government authorities, regulatory bodies, the consumers who are going to get products and services, the society at large. So all of us are stakeholders in a contract. Do not think of contract in isolation, that it is an agreement between two parties. There are so many stakeholders. Parties' reputation is at stake. Parties' business it is at stake. The workforce that the parties have. Contract has implication on their livelihood and well-being as well. So wherever there is a divergence in any of these aspects, it is a chaos everywhere. So what is the crux of effective drafting? Our drafting has to make our client's life simpler and better. The client should feel more empowered after having come to us. The client should not feel that his life has become more complicated after coming to us. We are telling him so many complicated things in legal language and jargon and legalese, whatever things we lawyers sometimes love to engage in. He should feel better off after having come to us. He should not feel scared after having come to us. And we should be able to add some value to the client's expectations. Otherwise, the client can always go to a stenotypist sitting in the district court with a chair and table and a typewriter. These people have all good templates. Why does a client come to a lawyer? The client comes to a lawyer because he feels you are professionally equipped to help him. You can address his concerns. You can enhance his rights and powers in a contract. You can reduce his liabilities, liabilities in a contract. And how do you do it? You be a miser with words. Now, this is a contrarian stand. Everyone generally assumes the longer a contract is, the better it is. The more detailed a contract terms are, more protected would a client feel. But that is not true. We have to cultivate smart working. We have to condense a lot of information that we get to hear from so many people. This is why I say lawyers must develop an ear. Lawyers have the habit of talking too much, writing too much. It is about time that lawyers learn to listen more and speak less. Develop an ear. This is why I say, because when you are drafting a contract, you have to listen to so many parties. You have to listen to your own client. You have to listen to the other party. You may have to listen to the other party's lawyers. You may have to listen to RBI. You may have to listen to SEBI. You may have to listen to TRI. Given the circumstances around a contract, sometimes government also get involved. Sometimes regulatory bodies also are stakeholders. So you hear everybody's concerns and you condense all this information. You capitulate all this information in as less words as possible in your draft. Ultimate aim is to provide something which is most beneficial to our client. Client is our universe. So whatever we draft must work to the benefit of our client. So the catchwords here are suno sabki or karo client ke interest ki, as long as it is within legal parameters. Everything has to be compliant and balanced as well, not too one-sided. And simplicity, as we said, our drafting should not be like marriage mantras or a doctor's prescription. All of us attend marriages, right? Marriage mantras, as far as Hindu marriages are concerned, are recited in Sanskrit language. To my knowledge, more than 95% of people cannot make out what the Panditji is saying, what mantras he is reciting. Am I correct, Vikasji? No one can make out what Panditji is saying. But do parties back out of marriages that we are not able to understand what are you saying?
They say that the agreements of a, let's assume, insurance company or the marriage vows are similar. You don't understand, but you always write, I agree.
Precisely. So you do not uh, dispute or challenge these mantras or insurance companies contracts, because you have already made up your mind कि ये policy तो मुझे लेनी है या ये शादी तो मुझे करनी है. You never back out despite not understanding it, because your so same happens with contract drafting also. If your clients have made up their minds in going ahead with this commercial understanding, for smaller clients in particular, written contracts are mere formality for them. They just don't care. They may not have good in-house legal teams to discuss, debate, and go through your drafts. They will assume that if they have hired you as a lawyer, they will rely on you. They will trust you that you are protecting their interests to the best of your abilities. And issues will come only 1 year or 2 year or 3 year, 5 years later in their relationship, when there are issues insofar as implementation or enforcement is concerned. So any problems will arise only later. At the time of entering into contract, your shoddy drafting or legalese or verbois or jargon will not stop any commercial contract unless the client has good in-house team. So marriage mantras no one understands. Doctor's prescription also no one understands. Only a pharmacist, a chemist can figure it out, right? So your drafting should be such that it is understandable to everyone. It should not be an L to L. It should not be a lawyer to lawyer communication. Your drafting should not be such that only lawyers, judges, arbitrators, regulatory bodies, only these people can make out what you have written. Anyone who's reading it should be able to make sense out of it. Now, all of us work on contracts with templates, the old drafts that we have in our own database, or we sometimes we also ask our friends or teammates or Google. We take a old draft and we start working on it. The trend invariably is you think 5, 6, 10 terms are different in all contracts. The rest is all the same. So you only change these terms and your job is done. Like you change the dates, you change the name of the parties, say a lease agreement or a sale deed, you change the property description, you change the rent amount or the sale consideration amount, notice period, this and that, just 5, 6, 10 terms you have changed and your job is done. This is the approach particularly for law students and young professionals. Senior ones like Vikas or me will not take this approach. We know the shortfalls of taking this cut, copy, paste approach. As we say in North India in Hindi, nakal mein bhi akal ki zarurat hoti hai. You cannot just go blindly. You have to understand and appreciate that every transaction, every agreement, every client is different. Every client's resources, bargaining power, mindset, it's all different. So you have to pay due respect to each contract and customize it as per the requirements of the present transaction. No one size fits all. It's not a blanket that you can put on anything and it will cover. One of the issues is that the template that you are working on may have been drawn or written or drafted on the opposite party's mandate. Like in the present case, if your client is the landlord has come to you, has asked you to draft a lease deed. And what if the template, the old draft that you are working on was drawn on a tenant's mandate? The tenant got that lease deed drafted and you are working on it. If you have not paid attention to this entire contract, you will not do justice. You will compromise your client's interest. And when you are working on a template given to you by, say, a friend or Google or anything, you are unaware of the respective bargaining strengths of the parties. Where did this negotiation start? Where did this negotiation end? Which party compromised on which provision? For what reason? You are not aware of that. So you cannot afford to follow any template, any good template blindly. This is why people come to lawyers. Otherwise, there are hundreds and thousands and millions of templates freely available on internet. Any client can copy and paste those templates and go ahead with the transaction. Why do people come to lawyers still in this IT age? Because of your inputs. So do not indulge in this cut, copy, paste blindly. And the template that you are working on may contain so many obsolete provisions, so many laws, rules, regulations, press notes, and so on. Every day our law is so dynamic. The rules and regulations keep changing virtually every day by way not only of enactments in parliaments, but executive orders, day in, day out, by way of delegated legislation. So you do not know which law, which rule, which regulation, which stamp duty, which fee, which cess may have been altered after this template. So your contract has to be updated all the time. So unless you actually pay attention to the draft, it will not work. So first problem is blind use of templates. Second biggest problem is not reading the entire contract. We concentrate on what we think are the superstars of a contract, the important provisions, what we think are important clauses. And we forget the standard terms and conditions, or what we call as boilerplate clauses. Because please correct me if I'm wrong. A dispute can arise out of any word in the contract, right? Anywhere in the contract. It does not necessarily have to be an operative or an important clause, right? It can be any word, any map, any government approval, anything that is there in the contract, right?
That's true. They said that in one of the typing, it was to be written that he was running around, and it was typed as he was running around. So the entire meaning changed.
Yes. So this word may be anywhere. It can be in the title, it can be party's description, it can be in recitals, it can be operative clauses, it can be boilerplate clause, it can be witness clause, it can be execution clause, it can be annexures. A dispute can arise out of anywhere in a contract. So you have to read the entire contract. You have to read the entire contract. And please keep this mindset in reading everything, not only contracts, but all pleadings, all notices, all emails in your day-to-day life, as far as your profession is concerned, particularly. Read the entire message completely and also cultivate a habit of reading between the lines, proverbially, as we call it. Read between the lines also, not only what is written, but what is the intent behind this. Start reading that also. So with the templates, first problem is blind use, cut, copy, paste. Second is not reading entirely. And the scary part is, if you have blindly cut, copy, pasted something, or not read the entire contract, not having understood the implications from all the clauses, and you have sent it to your client or the other party or the other party's lawyers. Once you have sent a draft, it is your baby, it is your production, it bears your trademark, your brand name. You own all the mistakes in it. You don't get a chance before your client to say that, this I had not seen, or this I had not read, or this I had not paid attention to, or this draft was provided to me by so and so person, or this came from this big 5 law firm, or I took it from this book, or I took it from this website. You cannot plead this before your client. Your client has engaged you. The client is paying you, and he's not paying this website or this author or this law firm. So in what we call in American terminology, the buck stops here. The responsibility, ultimate responsibility, lies with you for the mistakes that you have committed and for the mistakes that these other people may have committed. Suppose you have got a draft from a friend. Some law has undergone a change. Some ordinance was issued day before, I think yesterday, on Arbitration Act. If some provision has changed, who is supposed to incorporate this change? Is your friend who's sending you this template is supposed to change this? SEBI takeover code keeps undergoing changes. Insider trading rules keeps changing. Who is going to make these changes in your templates, in your drafts? Your friends? Or do you think Google is supposed to make change and make it up to date before providing you any template? So you own all the mistakes. So drafting is the scariest assignment that you can get. Generally, law students in particular think drafting is the easiest job for a lawyer. What is to be done? You get hold of a good template, make some changes, and that's it. For a 10-15 minutes, half an hour's job, you get thousands of rupees. This is what law students think, but this is not the case. Drafting is scariest of legal assignments that you can get. So how do you work on templates? First, read the entire template, entire draft to decide that is relevant. Whatever is not relevant, please eliminate it. Please delete it. Like in case of 2 private companies, SEBI regulations may not apply because they are not listed entities. And if the template that you are working on was a contract between 2 listed companies, so it has so many references to SEBI takeover code and SEBI insider trading rules and so on and so forth. So these SEBI references are useless in your present contract. So eliminate such like references. So that will happen only if you are reading a contract completely and carefully. So once you have read it, you will get to understand that these provisions are not relevant, not required in this contract. Okay, delete it. Then there could be some provisions which are there but need to be amended or updated to suit the requirement of your client or to incorporate the latest legal position. So you update in sync with the latest legal developments and amend it to suit the requirements of your client. Like there may be a clause which is relevant, but in its present form, it is against your client. So you may like to make it evenly balanced or favoring your client. So go ahead, amend that clause. Then you find out what other clauses should be there to protect my client's interest in terms of limiting his obligations or exposures or enhancing his rights, entitlements, benefits under the contract. Incorporate those provisions. Find out what is missing, what should be added. So working on templates is something we have to live with. Yes, we cannot draft a contract, 5-page, 10-page or 50-page contract out of scratch. We cannot manually do it all the time. Yes, we have to take help from a template, but these are few things that you can take into account while working on a template. Thereafter, pay attention to these elements. A good contract must have all these components. First and foremost, the subject matter of the contract. What is the transaction that the parties are undertaking under this contract? Explain that in detail. All nitty-gritties of the subject matter. What is the relationship of the parties? What is the transaction being carried out? If there are any preconditions to be satisfied to commensurate to start a relationship between the parties, mention that. Like if some eligibility conditions are there, if some documents are to be provided to satisfy the other party, if some payments are to be made, if some due diligence is to be undertaken, or if some government approvals are to be taken to proceed with a particular transaction, mention all these conditions in the contract. Then what are the respective rights and obligations of the parties? It should not be that only one party has rights and the other party has only obligations. All parties must have some rights and some obligations under the contract. Only then I think a contract is balanced and can work in harmony. Now, these rights and obligations will also include consideration. What are the parties getting out of this contract from each other? Whether they are getting products or some services or some money by entering this contract, or they are getting some promise by the other party to do something or not to do something. So rights and obligations, when there are we talk of rights and obligations, then we have to see that our clients' rights are expanded and obligations are limited as much as possible, yet keeping it balanced between the parties. So we have subject matter, we have preconditions, we have rights and obligations, including consideration. Then we come to a working framework. How will the parties work? How will the parties perform their functions under this contract? Then what is the time frame for this contract? What is the frequency of products and services being delivered, or say payments being made?
Bhumesh, your screen has gone totally black. Yeah, no, it's fine. Yeah.
Yes.
No, your screen had gone totally black. Now it's fine.
Right. Okay, wonderful. Representations and party warranties by the parties. What are the representations? What are the statements the parties are making to each other to convince the other party that yes, I'm capable, I'm experienced of performing my obligations under this contract? These are the statements made by the parties to convince each other about their capability to perform their obligations under the contract. And warranties are the backup plan, that what if my statements are not good? Then how do I compensate you? Like this, you can understand from a shopping example. We go to any showroom, the salesperson will show us some products, will explain all the performance standards, all the features, the pricing, and so on and so forth about the product. That these are the performance parameters this product is likely to meet. The idea behind making these statements is to convince us to buy this product. So these are representations, and warranties are what are the backup options if these statements are not good. What if these products do not conform to the standards promised to us by the salesperson? What will be my recourse? Will I get a replacement? Will I get a repair? Will I get a refund? These are warranties or damages that I'm entitled to. Next important component is dispute resolution. What if the party were unable to live in harmony? What do they do then? How do they resolve their misunderstandings or disputes or gaps in their understanding? So your contract must provide for a good, effective, economical dispute resolution mechanism. And last but not the least is the termination mechanism. At any point of time, the parties should be able to get out of an uneasy or uneconomical relationship, something that is not working well between the parties. We should have the flexibility to get our clients out of that relationship. No one should be forced to live in an unhappy marriage. So this is like a divorce provision in a contract. So unless these components are there in your contract, you can safely assume that your contract is incomplete. So before finalizing any contract, before sending any contract to your client or the other party or the other party's lawyers or anyone for that matter, please check your contract on these parameters. Tick all these boxes, whether your contract has all these components or not, because sometimes you may find it funny, but in all these lectures and discussions and boot camps, even lawyers ask me, sir, this contract did not have a termination mechanism. What do we do? Sir, what if this contract did not have a dispute resolution clause? I say, why should a contract not have these clauses? What good a lawyer you are if you're not providing for a dispute resolution clause or a termination clause, or you're not mentioning rights and obligations of the parties clearly in a contract? Then what are you doing? So we should never ever let our client fall in such trap. There should be no contract which does not have all these conditions, all these components. We should never allow such a situation. Okay. If we come to a sequence of a contract, last time Vikasji had asked me that every contract has a flow. Yes, every contract has a flow of how the clauses should run. So we can broadly divide a contract into 4 parts. The first part is the preamble clause or introduction clause. This provides the reader information about this contract structure or essence as to what this contract is going to be, who are the parties to contract, and so on and so forth. So this is the first part. This captures first the title of a contract, thereafter the parties description, who are the parties to this contract. Third part is the recital clauses, which are whereas clauses or the background clauses or the introduction clauses. These recitals provide us information who the parties are, what is their business, what is their understanding on the issue so far, and what is it that they intend to do through this contract. And the last part in preamble or introduction section is the agreement clause, which is like the I do or Kubul hai clause. There, the parties say, the parties agree as under, or the parties hereby accept the following terms and conditions, and so on and so forth. So this captures the first part of the contract from title to the agreement clause. This is the preamble or introduction section. Thereafter, we have the operative clauses. These operative clauses are the, again, what we generally assume are the most important part of a contract, the most important distinct features of a contract. Like in case of property deals, these would have, the property details, the rent, the advance, the notice period, and so on and so forth. Or in case of products and services, these would provide information on the products, the services, the frequency, and so on and so forth. These are operative clauses. These cannot be lifted from one place to another place. These are peculiar to each contract invariably. These are distinct features of a contract. Then we have standard terms and conditions, or what we call as boilerplate clauses. These are standard terms in invariably all contracts, and these can be transposed from one contract to other contract easily, comparatively easily. Having said that, we have to pay equal attention to them. We have to read them carefully, whether these are actually as relevant in this agreement or some fine tuning is required. Fourth and last part are the annexures. So many contracts we keep referring to some government approval or some property map or some business plan or articles of association of a company, or it could be some policy of the government, or could be anything. So these, instead of incorporating within the body of the contract, which will disturb the flow of the contract, we attach them as annexures. So these are broadly the four parts, and this is the order in which they have to be placed. Thereafter, we can discuss normally this again is the flow of a contract in terms of clauses. First, we have the title of the contract. The title should be reflective of the business that the parties are going to carry through this contract, like loan agreement or lease agreement or partnership agreement or joint venture agreement or technology transfer agreement or a franchise agreement or a distributorship agreement or an agency agreement, right? That would either show the parties' relationship or that will show the business to be carried out under this contract. Then we have parties description, who are the parties, their registered office, and so on and so forth, identification of the parties. Then we have recital clauses. Thereafter we have agreement clause. Then if there are some terms used at various places in the contract, we have definition clause. Thereafter we have clauses which explain the transaction. And thereafter we have the consideration clause. What is the consideration for the parties in this contract? What will be the frequency of delivery of products and services or payments, and so on and so forth. Other operative clauses: dispute resolution, termination. Okay. Sorry, I ran too fast. Execution by the parties, in witness whereof parties hereby sign this. Signatures of the parties, witnesses if there are any witnesses to the contract, and annexure. This is the flow of clauses in a contract. I mean, if we have more sessions, maybe we can go through all these aspects one by one in detail. We keep having our 6-hour master classes on this subject also.
Yeah. But in any way,
So this I had discussed last time also in our top 10 criteria for an effective contract. You may note it down if you wish to. And if you have any questions, I mean, we can take it after 5 minutes. So your contract has to be very crisp, clear, concise, precise, complete in all respect, compliant with all laws, all the provisions. It should make common sense. Nothing should be absurd or unreasonable or not sounding reason. Should be dynamic to adapt to anything like COVID-19. Whatever, if circumstances change, the contract should also be capable of being accommodated accordingly. Should sound originality. It should not be a cut, copy, paste. Anyone can make out which draft you have copied, which clauses you have taken from which law firm's template. It should be original. It should bear your own style. Should be balanced. It should take interest of all parties in concern. If a contract is not balanced, it will not work out eventually. A party may enter into a contract under duress today because it is on suffering from hard times, but then the relationship will not be good and it will not work out. And all checked in would mean all provisions should be paid equal attention. Everything, as I have been emphasizing throughout our discussion, that every provision must be paid good attention, because a dispute can arise and misunderstanding could arise, ambiguity could arise from anywhere in the contract. So all provisions should be properly checked. And here we may briefly discuss for a minute in litigation drafting and contract drafting. People who are more into litigation drafting may substantiate as to what I'm saying. In litigation, our emphasis is on winning a case. When we go to a court or an arbitrator, our sole objective is to win a case for our client, right? And we cannot afford having regard or concern about the other party. Our client is our sole interest in a litigation matter. More often than not, we do not care about the other party. And we have to emphasize, shout means not necessarily shouting verbally, but shout here would mean emphasize on our strong points. And in emphasizing our strong points, we tend to get repetitive at times. That's why we have such bulky petitions. Well, such bulky submissions, written submissions all the time in litigation. The focus and emphasis in contract drafting is for the parties to collaborate. You have to bring two or more parties whose expectations from the same commercial transaction are different. Like a seller wants 1 crore rupees for his property and the buyer wants to buy that at 50 lakhs. We have to bring them to a place where both of them feel comfortable. Similarly, for products and services, the provider of these products or services wants some price. The buyer of such products or services wants them at much less price and much more favorable terms and conditions. So we have to bring them on a common platform. So the idea here is to collaborate and envisage a long-term relationship. Litigation, you're not doing it to create a relationship. In litigation, you're not creating a relationship. You may be breaking a relationship, in fact, most of the times. So in order for parties to collaborate, you have to balance their rights and obligations. You have to undertake a give and take approach, and you have to be to the point, crisp, precise, concise, as I keep saying. So this may be the distinction between litigation drafting and contracts drafting. Okay, good. Again, we are at the end of our session today. So you can keep notes if you have kept. You can follow us on our LinkedIn pages, read articles and books. There are very good online courses on this subject, particularly by Loctopus. They run a contract drafting course with us on this subject. We have a Telegram group wherein we share a daily tip on contract drafting. As Vikas said, today I shared 108th tip. I had promised to share 500 tips at least. It may go beyond that also. And this is not a theoretical subject. This is a practical subject. So keep practicing. This is the book, which is available on online platforms, bookshops. Kindle version is also there. So if you wish to pursue the subject in seriousness, this may help you. Yes, we can take any questions.
Yeah, this is by Santosh Gavde. In a contract disputes, resolution clause speaks about civil court jurisdiction for resolution, whereas general rules of contract speaks about arbitration, which shall have the first jurisdiction to decide the dispute.
Because I think you are best suited for this. इसका आंसर आप भी दे सकते हैं ना, आप मुझसे बेटर दे सकते हैं.
So it's a choice how you understand, but if you agree for a third party resolution, nowadays even in the alternate dispute redressals, they are also incorporating that first they should go for a mediation, or like in a governmental institution, they also go for the fact that first they will try to have a common mediator who can help to seamlessly decide the matter.
Right. Most of the times these days, parties try to have an alternate dispute resolution in place rather than going to litigation, which is a more, I would say, expensive and time consuming and more public forum. Parties try to resolve it first at their own executives level, if possible. If not, they would take it to mediation or arbitration, as Vikasji said. Litigation these days should be the last resort for resolving any commercial dispute.
This is by Dr. Srinivas. He says, prenuptial agreements in a marriage, how far it is valid in India?
नहीं सर, अभी तक तो कोई इस पे rules regulations नहीं है, to my knowledge. Vikas can correct me if there is some.
As such, no. There are loud thoughts going according to me also, but we haven't come across.
अभी कुछ नहीं है.
And then further auction would be as to how, whether it is against the public policy, etc., etc. They are the larger contours to be discussed.
Yes.
I'll just check it out if we have any question on Facebook.
Because in India, we consider marriage as a sacred thing, not a contract, as maybe in some other communities.
He wants to know the online course.
Online course, yeah, you can check Loctopus with my name or Copcom legal name. You will get access to it. If you want, I can share a link with Vikas. He can provide you.
Yeah.
But you can check it online. Loctopus contract drafting course. You'll get access to it.
The next is, if parties didn't want termination clause, even after suggesting, then what should be the stand?
Then these parties will come after 5 years or 10 years, running after you, crying that relationship is not going good. What do? Till 1956, we did not have a divorce provision for under Hindu law, right, Vikasji?
Yeah.
A need was felt and a law was enacted. So termination, if parties want a perpetual contract, God help them. And anything original costs much less than repairs. If there is a termination clause, parties know how to terminate. But if there is no termination clause, one party wants to terminate, the other party does not want to terminate. There is a dispute. Then the parties go to courts, go to arbitrators, go here and there, not knowing what to do. I mean, is that process better for the parties? I really don't know.
No, even otherwise, any open-ended, like what you said, it should be concise, precise, and concise. So any agreement which is open-ended and it is bound to have a larger interpretation. Let's assume you do not decide a jurisdiction. Let's assume you do not decide the dispute resolution procedure. So that is why even if there are special acts, they always provide what are the resolution. Let's assume there's a Securitization Act,
Yes.
appellate authority, or any authority, you will always find where your first case would lie, then the appellate authority, and then what are the fees, etc. Because
Yes.
anywhere which has a gray-ended area would always be more confusing rather than giving a right sense. We
As professionals, it is our job to educate the parties, apprise them of their rights and obligations, and emphasize upon them this is for your benefit.
Yeah. He says, why again example of divorce and marriage? That is, he wants, Mr. Bhumesh wants to say that whatever situation you want, one should always be prepared for an example with the worst scenario. Otherwise, what they say, that they say marriages are always decided in by God, and that is why saat janam ka saath. Yeah.
But if parties cannot live in a harmonious relationship, be it personal life or professional life, they should have an exit route. I mean, no offense intended, but this is, the analogy. You can drive in your private life. You have this option under law. Similarly, you have an option in a contract to get out of an uneasy, uncomfortable relationship.
He's asking again for the online course. Yeah, you have already written. Yeah. So, thank you, Mr. Bhumesh. It was quite an engaging session. And once, if one understands the smaller issues which could actually crop up at a subsequent stage, it is better to nip them at the bud. And once you understand the contract, how to go about it, it is always better that it should be all the points, bullet points should be incorporated in the same, lest it creates trouble. And like what Mr. Bhumesh said, that the original draft would cost less, but the repairing cost will cost more. That is, you will have to engage more lawyers, more interpretation. So it's better to put it everything in black and white rather than keeping it in gray shades and gray colors. And tomorrow's session would be law on pension with emphasis on military pension, a talk followed by question answers. At 4 p.m. by Major Navdeep Singh, who is an advocate of Punjab Haryana High Court, a dear friend of mine. And he's also the founder, president of the Armed Forces Tribunal. He played a pivotal role and his assistants were there in the this tribunalization of the cases. And even otherwise, he has also written a book, just like Mr. Bhumesh, on law of military pensions. So do stay connected with us tomorrow at 4 p.m. Everyone stay safe, stay blessed. And we are thankful to Mr. Bhumesh for giving the insightful session. And I'm quite sure that the seeds sown by him would actually translate into the trees which will ultimately bear fruits for the society at large. Thank you, Mr. Bhumesh, and to all the participants who are watching us live on the Facebook and on this platform. Namaskar and Jai Hind.